Understanding pregnancy disability. Leave across the United States. Navigating pregnancy-related leave protections in the workplace. Pregnancy disability leave, or PDL, is a critical protection that allows employees to take time off when they are unable to work due to pregnancy, childbirth, or related medical conditions. However, the specifics of PDL vary significantly across the United States, shaped by a combination of federal and state laws. Understanding these differences is essential for employees and employers to ensure compliance and proper support in the workplace, according to the U.S. Department of Labor. At the federal level, the Family and Medical Leave Act, or FMLA, serves as the primary regulation governing leave for pregnancy-related medical conditions. Under FMLA, eligible employees are entitled to up to 12 weeks of unpaid, job-protected leave per year for specified family and medical reasons, including the birth of a child or a serious health condition, as outlined by the U.S. Department of Labor. To qualify for FMLA, employees must have worked for their employer for at least 12 months, accumulated at least 1,250 hours of service during the preceding year, and be employed at a location where the company has 50 or more employees within a 75-mile radius. It is important to note that time taken off due to pregnancy complications can be counted against the 12 weeks of FMLA leave. However, FMLA does not mandate paid leave, which means employees must rely on employer policies or state-provided benefits for wage replacement during their absence, according to the U.S. Department of Labor. Beyond the federal framework, state laws play a significant role in shaping PDL policies. Some states have enacted robust paid leave programs, while others rely solely on the provisions outlined in FMLA, according to the Bipartisan Policy Center. As of 2025, 13 states and the District of Columbia have established mandatory paid family leave systems, including California, Connecticut, Colorado, Delaware, Maine, Maryland, Massachusetts, Minnesota, New Jersey, New York, Oregon, Rhode Island, and Washington. These states typically provide partial wage replacement benefits through state-administered insurance programs, allowing employees to take time off while maintaining financial stability, states the Bipartisan Policy Center. In contrast, several states do not have specific PDL laws beyond the federal FMLA, leaving employees with limited or no additional pregnancy-related leave protections. For example, states such as Texas and Mississippi do not mandate additional maternity leave benefits beyond what is required under federal law, according to Paycor. Given the variations in PDL policies across states, employers must stay informed about federal and state-specific regulations to maintain compliance and support their employees. Employers should ensure that their policies are up to date, clearly communicated, and aligned with legal requirements as advised by the U.S. Department of Labor. Employees should take proactive steps to consult their state's labor department or a legal advisor to understand their rights, available benefits, and the process for requesting leave. Since PDL laws differ by state, employees should also check whether they qualify for state disability insurance or paid family leave programs to receive financial assistance during their leave, according to the National Conference of State Legislatures. In states like California, which offer PDL, the leave applies to employees who are medically disabled due to pregnancy-related conditions. Unlike FMLA, which has eligibility requirements based on tenure and hours worked, California's pregnancy disability leave is available to all employees working for an employer with at least 5 employees, states the California Department of Fair Employment and Housing. To qualify for PDL, an employee must provide medical certification from a licensed healthcare provider stating that their pregnancy or related condition prevents them from performing essential job functions. The certification should outline the need for leave and its expected duration. If an employee can perform specific job duties but requires adjustments, such as reduced lifting, more frequent breaks, or temporary job modifications, the employer must consider reasonable accommodations before approving leave, states the California Department of Fair Employment and Housing. In states that mandate pregnancy disability leave, employees may take up to 4 months or 17.3 work weeks of unpaid job-protected leave per pregnancy. This leave can be taken as a continuous block or intermittently based on medical necessity, according to PayCor. Some employees may need to take PDL continuously due to complications during pregnancy or for postpartum recovery. Others may require intermittent leave, using shorter increments of time off for prenatal appointments, bed rest, or managing pregnancy-related health conditions such as gestational diabetes or hypertension. The flexibility of intermittent leave allows employees to balance their work obligations while addressing medical needs, states PayCor. PDL often overlaps with other federal and state leave entitlements, creating a complex web of benefits that employees and HR professionals must navigate. If an employee qualifies for FMLA, PDL may run concurrently with up to 12 weeks of FMLA leave. However, if medically necessary, PDL extends beyond the 12-week limit, according to the U.S. Department of Labor. In California, the California Family Rights Act provides 12 additional weeks of baby bonding leave after PDL ends. When combining PDL and CFRA leave, a new parent could take nearly 7 months of job-protected leave, according to the National Conference of State Legislatures. For HR professionals and business leaders, maintaining legal compliance and implementing best practices is key to supporting employees while minimizing workplace disruptions. Employers should regularly update their leave policies to meet state and federal requirements. Transparent communication with employees regarding their rights and the process for requesting PDL is also essential. Additionally, proper record-keeping is necessary to track leave usage and prevent disputes, states the National Conference of State Legislatures. Employers should also explore reasonable accommodations before granting extended leave. Adjustments may include modifying work schedules, providing ergonomic accommodations, or allowing remote work if feasible. Engaging in the interactive process with employees to determine appropriate accommodations is required under the Americans with Disabilities Act and state employment laws, according to the National Conference of State Legislatures. To wrap this up, pregnancy disability leave (PDL) plays a crucial role in protecting employees from job loss due to pregnancy-related medical conditions. However, PDL policies vary widely across states, and understanding the distinctions between federal and state-level protections is essential for both employers and employees, states the U.S. Department of Labor. For HR professionals, ensuring compliance with evolving leave laws, implementing reasonable accommodations, and fostering a supportive workplace environment will enhance employee well-being while maintaining productivity. Employees should take proactive steps to understand their rights and available benefits, including wage replacement options offered through state disability insurance and paid family leave programs, states the National Conference of State Legislatures. As leave protections expand in some states, businesses must remain adaptable and well-informed to create inclusive workplaces that accommodate the diverse needs of employees, according to the U.S. Department of Labor. Get ahead in HR strategy. Watch now and gain the tools to elevate your role as an HR leader. Like, comment, and subscribe for expert HR insights and actionable strategies.